Hello and welcome to this webinar about the TFP documents. We're glad to have you all on board. I can see that we have probably about 60–70% of the people we're expecting to have, so I expect we'll get some more booking on in the next few minutes. We'll see how that goes on. Just to explain a little bit whilst people are still booking on, two things. If you are using the telephone and you don't enter an audio PIN number, then my able assistant, who is with me online as well, Nick, he will send you an audio PIN reminder, which is just usually a 2 or 3 digit number followed by a hash sign. And what that enables the system to do is to know which telephone line represents which person, because obviously those two systems are different. I can also see many of you are online using what they call computer audio. In other words, rather than using the phone to phone in, you are using the computer. That doesn't need a PIN, but what it does need is, obviously, in order to ask questions, you have to be able to have a microphone and speakers. I'll come back to that in just a moment. Now, the first thing I'm going to do is to launch a poll. If I could just ask you to click the yes or the no option. The reason that we do that is because we can then identify who is or is not able to actually hear what I'm saying. Most people have voted. There are a couple who can't hear me talking, and therefore I will just close that poll. Doesn't matter how many there are. I'll close the poll and pop up another slide. Just gives people some information if they have that problem, what they can do. One of the ways around it is actually to just switch and use the phone system as we explain on that slide. For those of you who are using computer audio, if you wish to ask what I'll call an audio question, anybody to ask an audio question on the control panel, which normally seats itself in the top right-hand corner of your screen. You'll see on that audio panel there is a little hand, and you can actually click on the hand. That shows our end that you've put your hand up, and when you put your hand up, I will take that as meaning that you wish to ask an audio question. We can then come to you and we can talk to you and engage with you. But I will just point out before we start two things. First of all, if you're via the computer, it only works obviously if you have a microphone on the computer, standard in many laptops, but not in desktops. So just make sure that you are able to use a microphone for the computer. Otherwise, we'll unmute you, but we'll hear nothing at our end. The second thing to say is, of course, the fact that everybody else will hear what you say as well. In other words, you will be publicized to the whole webinar, just so that you're aware of what's happening there. So that is asking questions using audio. You have that facility, and we will do it via putting your hand up. I will put everybody's hand down. We have that facility here, just to make sure we've cleared that before we start. The second way you can ask a question is on the same sort of control panel you have the ability to type in a question. And if you type in a question, then Nick, who is assisting me today, he's in the background and he will be typing in answers to questions. When you're busy giving the actual webinar, it's too difficult sort of multitasking to be able to type and answers and read questions and everything all at the same time. So I'll do the audio bit and run the slides, and Nick in the background, he will be dealing with the typed in answers. He may choose to interrupt me and share any questions that he feels are particularly pertinent and should be shared with the wider group. All being well, the technical gremlins, if we can keep them in their box, we are recording the webinar and you should be able to access a copy. I'm not quite sure how you will access that copy because we will provide it to PFG and then obviously up to them as to how they supply that to you. Just while I'm talking of technical gremlins, one thing we are aware of is that the discount code we set up for the current series of courses so that PFG members get a 25% discount, that is not working. The technical gremlins have been involved there. Our web people who run the site, they're currently sorting that out. So bear with us while we get that sorted. We can book you on and override the system and give you the discount manually. But if you just give it a day or two, then you should be able to book on directly. So moving on then, we've given a little bit of time for those who were unable to hear the audio. Hopefully they've managed to now phone in or something similar. So let's move on, sort of where are we going today? There are essentially two packages, if I use that word, involved in what we're talking about today. The first one is the tenancy agreements package. And whilst we refer to it as the tenancy agreement package, actually there's a lot more to it than a tenancy agreement, and you'll see that as we go through. It includes all what I'll call the common notices that you're going to need, prescribed information, all sorts of other things in addition to tenancies. But it's all things around the tenancy agreement. The second package that we're going to talk about today is the management forms package. And that is a whole load of things that are what I'll call outside of the tenancy, but it does include, for example, things like tenant application forms, contractor paperwork, documents to help you with GDPR compliance, Legionella management, all those sort of things there, including, of course, the terms of business. And what we find from customers is that one of the most useful things they find about our package is that it helps them keep documents up to date because it is a proactive system. In other words, we are always monitoring court cases and legal changes. And if there are any court cases or legal changes, then what we do is we will update the documents and we will send out an email to our subscribers letting you know that there is a new Section 21 notice or whatever the document change has been. Just whilst talking about that Section 21 change, I will just say one thing, and that is the fact that you need to understand that the Section 21 is a prescribed form. That literally means that Parliament has said this is what the form has to say. And what we've had in the last year or so, I don't think I remember it happening so much before, but certainly in the last year or so, we have had MHCLG publishing their own versions of these forms. So the actual version of the Section 21 that is legally prescribed in law, that appeared in the legislation at the end of May. And then we had an updated version from MHCLG, I think it was early June, another one in July, and another one in August. And in fact, none of those three from MHCLG are what I would call legally valid. I mean legally valid in the sense of saying they match the legislation. The first two, they got further and further away from the legislation and the version in the law. The third change moved it back nearer the legislation, but it's still not quite exact. And I'll be quite honest, the current Section 21 has some interesting wording and grammar in it. You know, things that you would say, well, that's clearly grammatically wrong. But we put that in the document, even though it's grammatically wrong, because that's what the law says. And if you use what the law says, you can't be wrong. The minute you change it away to anything else, there is a danger that a judge might argue, well, that's not valid because it's not identical. So just be aware of that. And if there is something that needs changing, we let our customers know. And we sometimes get people ringing up and saying, oh, I've read in the press about a new Section 21. Very often those changes have been changes by MHCLG to their version and are not changes in the law. So looking first of all at the tenancy agreements package, the law in England and Wales is increasingly diverging. They have what is referred to as a devolved power in Wales. And so we have split the pack into English and Welsh. They have different Section 8 notices, different Section 21 notices. They now, of course, have a different tenant fee ban legislation, that the actual law is different. And we are also very mindful of the fact that Wales are heading towards the Renting Homes 2016 Act in Wales, which will scrap assured short hold tenancies and replace them with occupation contracts. So we have split those documents entirely. Some of the documents are exactly the same in both packs, but in other cases, the documents are different. If you operate in Wales, obviously you can use just the Welsh ones. If you operate in England, just the English. But we are very mindful that from somewhere around about Gloucester North, you will get agents up that border strip who may have properties in England or in Wales, and they'll have to obviously access both different sets of documents to ensure they use the right one based on where the property is. So there are a number of folders that we provide in there. The first one is about notices. We've tried to group things logically together. There are a number of different notices. I'll show you these in just a minute and explain them. There's an other documents folder, which doesn't really fit neatly into any category. It's a sort of miscellaneous type thing. We provide a range of documents in a range of formats that are what we refer to here as ready to use. I mean, in reality, they're not ready to use because they don't have the tenant's name or the landlord's name or any of that sort of information in. It's a little bit of an historical name because we used to provide the one master copy and give you the information as to how to change it for the different deposit schemes. And then we switched over to this sort of ready to use type idea. So those are just where the tenancy agreements are. And the next one we have is what I refer to as standalone prescribed information. I'll explain this when I show you a tenancy agreement in just a moment, but basically our tenancy agreement includes the prescribed information within the tenancy agreement. Now, because we do that, there is no requirement to give separate prescribed information to the tenant other than the information that the scheme provide in a leaflet for the tenant. Now, the reason we don't provide that information within our tenancy is that obviously we're not members of the 3 deposit schemes, so they don't tell us when they change the scheme leaflets. And therefore, it's not something we're able to sort of manage in terms of knowing when there's an update. As a member, you would expect them to be contacting you and telling you we've issued a new document, therefore use this from now on. And that's the call to you. So that is something that's part in law of the prescribed information, but we do not provide because it comes from the scheme. They dictate it, we don't. The standalone prescribed information as a folder, the documents in there, they're really designed for situations where maybe you take over the management of a property from another agent or from a landlord who was self-managing. You do not need to issue a new tenancy agreement in those circumstances, but you do need potentially to give new prescribed information because you have received a deposit, and therefore on receipt of a deposit, they triggers the requirement for prescribed information. So that's just standalone versions, and I'll show you those as we go through. So moving, and I'll show you the folder of those before we come back. So essentially you can see I've got a folder there that is split between England and Wales. I'll only look at the English one, and there's pretty much the same in the Welsh one, but obviously with slightly different wording in the details. You don't quite see all the folders I see because obviously I have to administer the system. So in the notices folder, the first 3, if I highlight those, they are what we refer to as prior notice grounds. In other words, if you want to rely on repossessing a property based on one of those grounds, the law says that before the tenancy was granted, you must have given the tenant notice warning them that you might seek possession. I don't actually recommend they're used by default at the moment, but there are some mortgage lenders who will, for example, insist on those grounds, which is fine. The next one we have down, the 4th document there, is the notice to quit by the landlord. That is not to be confused with a Section 21 notice, people use the language quite often, but wrongly. A Section 21 is not a notice to quit. There is, under the Protection from Eviction Act, Section 5, a legal obligation on a landlord to give a notice to quit. So, for example, if you had a letting to a company that was a monthly tenancy, the law would require you to use that notice to quit document. Section 8 and 21 are notices seeking possession and requiring possession. So that notice to quit is not something you'll use other than for tenancies that are outside the Housing Act. We do provide a notice to quit from the tenant. Obviously, it's not something you're likely to use, but if your tenant needs to give a notice to quit, then we just give you a document that they can use that sort of matches the requirements of notice to quit legislation. Schedule 2 grounds, you'll be familiar, for example, with Ground 8 for rent arrears, and all these Schedule 2 grounds do is they literally give you the wording of those grounds. I know it is a PFG policy that you do not fill out Section 8 notices, and the most common time you're likely to want to use this document is to put that information on a Section 8 notice. But equally, if you just wanted to look up, say, Ground 14, which is around the antisocial behaviour legislation, you would be able to look that up in there. And Ground 14, if I open it, you will see in Ground 14, I can scroll down, we can find Ground 14, and you'll see there that a person, or a tenant or a person residing in the dwelling house has been guilty of conduct causing nuisance or annoyance. So if you want to see quite what the wording said, this is word for word what the legislation says in its up-to-date format. And that's an example of where there is slightly different grounds available in Wales.
David, I see that. David, sorry to interrupt you. I see that Matt has a question which has been asked by somebody else, which it might be worth addressing at this point in time.
Yes, I can see Matt's question. Now that you bring my attention to it, I'm busy looking at another screen, but thank you for that, Nick. The question Matt has asked just there is, do these documents integrate with Dupix? And the answer essentially is yes, the tenancy agreements and the notices and things do integrate with the software. I think it's Dupix and Repit, the two different systems, depending on the brand you're with. It is in both of those. Not necessarily exactly in the same way as we do it, because obviously when it's put in the software, it has to fit with the way the software works. Section 3 notice here is a change of landlord. It's one that I'm amazed isn't more commonly done by solicitors, but basically when the landlord changes, that could be the sale of a property or it could be the property's inherited. Either of those circumstances, it is a legal requirement to serve notice to tell the tenant that their landlord has changed. And so we just give you a Section 3 notice. As I say, arguably, you shouldn't really have to do it. I just find from experience that many times solicitors don't do it. I mentioned the Section 8 notice, which is there, but we'll pass on from that one. Now, Section 13 notice, again, these are Housing Act notices here, Section 8 and 13. Section 13 is the rent increase notice. With our tenancy, you do not need to use the Section 13 notice in terms of in the way we supply it by default, because we actually build a rent increase into the tenancy agreement. And the Section 13 notice is only used where there is no rent increase built into the tenancy agreement. And then we have Section 21 notices. You'll actually see that there are 3 Section 21 notices. The top one, which you'll see Section 21 notice Form 6A, although it says for use after the 1st of June 2019, that is because it is the updated form that was for use after the 1st of June. But the whole of Form 6A is actually only needed for tenancies after the 1st of October 2015, and the second 2 notices underneath can still be used for pre-October 15 tenancies. Having said that, there is a lot of confusion about that point. Legally, that is correct. and it may be that you would be just as well to use the Form 6A, which very clearly on it says you must use it for these cases, but you can use it for any assured short hold. And so it would cause less confusion to use Form 6A. So that's the Section 21 notice. And down the bottom, we have what I'll call a standalone Section 48 notice. Again, the Section 48 notice is actually built into the tenancy agreement. You'll see that in just a moment. But if, for example, you moved offices, you would need to serve a new Section 48 notice on every tenant to give them a new notice for the address for service of documents. And that's really what that standalone version is all about. I mentioned other documents. The first other document is the top one here, the agreement to lease. This has actually been a surprisingly important document following the introduction of the tenant fee ban, because there are certain things within the tenant fee ban you have to do. And we're trying to use this as a way of complying with that. It's basically an agreement to set up a tenancy at a future date. In other words, you will, very, very common with student lets, particularly where you might do a viewing in October and they don't move in till the following August. But even if they're not going to move in for a week or two, the agreement to lease simply clarifies, for example, what the deadline for agreement is. That's part of the new tenant fee ban legislation. So we've built that into the agreement to lease. It also clarifies when they'll get their money back, if the landlord changes his mind, for example, and when they won't get their money back, for example, if they change their mind. And so that just clarifies everybody's thinking around that one. Now, when I get on to show you the tenancy agreement in a moment, you'll see that the standard tenancy agreement includes a break clause, but it's a slightly unusual break clause that I will explain. And we do give you the option to end it halfway through or whatever you want, a fixed term. And that's what the break clause 6 out of 12 months means. It's basically wording to use in that circumstance. And I'll show you the difference when we talk about it. Our tenancies are unusual in that we grant a fixed term from and including a date to and including a date, and the tenancy then continues as a monthly periodic. What we're essentially doing is we are avoiding tenancies going statutory periodic, and there are several advantages around that, one of which is that if the tenant just walks out of the property unannounced, you might not know it for a few weeks. With a statutory periodic, the day the tenant walks out of the property, the landlord is liable for the council tax. To protect the landlords and avoid that problem, our form of agreement leaves the tenant liable for the property when they walk out in that scenario. And this letter is just a letter explaining to the council, who will very likely come to the landlord and demand the money, why you are not liable for that money. It's the tenant's responsibility. In deposit legislation, we have a person called a relevant person, somebody who funds the deposit on behalf of the tenant, and they are by law required to be included in the prescribed information. Their details must be in there, and they must also be given a copy of the prescribed information. Otherwise, you have not complied with deposit legislation, and this document simply explains what a relevant person is. Some of the schemes use the lead tenant, and if they do use a lead tenant, My Deposit still does. The custodial scheme has changed their wording to a nominated tenant, and the DPS, TDS, they don't sort of talk about it or use it at all. You will see that in our tenancy agreement, we include an agreement about who will be the lead tenant. And if you for some reason want to change it, maybe the lead tenant is moving, then this document is a way of just getting everybody's agreement that the lead tenant will no longer be John, it'll now be Paul or whatever it's going to be. And that's very much the same as the lead tenant declaration. The letter of surrender, I'm a fan of surrenders. To me, they are the most powerful and probably one of the most important ways of ending tenancies. And this letter of surrender is a very simple document. I actually think you should probably print copies and carry them around in the folder in the car with you. You know, you never know when you're going to meet the tenant somewhere and they're wanting out. This just gives you a simple way of getting written evidence that they've wanted to surrender the tenancy, and then you accept it. Paragraph numbers refers to our tenancy agreement, and it just lists all the paragraph numbers so that if you add in 3 extra paragraphs, you can record how you needed to renumber the agreement. Because obviously when we do an update, we provide a list of all the changes to the document, but we refer to our paragraph numbers. And if you use different numbers, you would not realize that when we would say, well, we've edited clause 4.28, if you've deleted 428 or you've removed 427 and 428 has now become 427, it would be confusing. So this just deals with that situation. There can be issues around collecting rent in advance, where you want to collect, say, 6 months rent up front. It's possible to do so, but we need to be careful. It's probably something that our advice in Wales would be not to do it because of the way the legislation has been worded. In England, it works, but in Wales, their wording of the legislation is different, and we have concerns about that. So our advice would be don't do it, but that just explains how to create the right wording for use in that scenario. One of the tricks to avoid the rent in advance being considered a deposit is to ensure that you define the rent for the first 6 months will be X, rather than just leaving it as a monthly rental. The relevant person holding deposit agreement is an interesting one because if somebody else pays the holding deposit on behalf of the tenant, they really need to know in what circumstances they'll get their money back or in what circumstances they won't. And therefore, that's what this document clarifies. It's essentially very similar to the top agreement to lease document, but instead of agreeing to take out a tenancy, that bit of it is missing. But the rest of it is there explaining that if the tenant changes their mind, then they will be charged the reasonable costs under the Tenant Fees Act. But if the landlord changes their mind, then the tenant will get their money back, etc., etc. So that if the relevant person is going to pay a holding deposit, they are aware of the circumstances in which they may or may not get their money back, which is necessary in order for it to be enforceable. Of course, part of the Tenant Fees Act is to introduce this new concept of a deadline for agreement, basically the point by which the tenancy needs to have started. And if it hasn't started, then essentially the holding deposit becomes refundable to the tenant. The actual deadline for agreement you'll find in the agreement to lease, but it is possible that through circumstances outside anybody's control, you may need to change that. In other words, you might have envisaged that you could move them in 2 weeks' time, but as that date moves up, current tenant fails to vacate, they leave the property in a very bad condition, something like that. And so you need to move the deadline for agreement. So this last document here is simply an agreement to vary the deadline for agreement after the original has been set up. There's no reason, if you know the tenant is not going to move in for 3 weeks, 4 weeks, 5 weeks, to set the original deadline for agreement to whatever length you want it. This is really only dealing with a scenario where circumstances change and you need to delay it longer than you thought. I have seen people sort of saying you need to agree every 2 weeks that the deadline is extended. That is not true. Although there is a default of 14 days, you can, provided it's done in writing, agree any other date you want. Moving on then to the ready-to-use agreements, a lot of the agreements are very, very similar. If we start at the bottom of the list, if you look at, if I use the word the naming protocol, it'll help you understand it. So we've called this one the DPS, as in the Deposit Protection Scheme Computer Share. The bottom one is an insured scheme where the landlord is managing the property. The one above is an insured scheme where the agent is managing the property. The one above that is a custodial tenancy where the landlord is managing. Then you've got the custodial with the agent managing, and you'll see that pattern is repeated in most of the agreements, where for the deposit schemes, they'll have insured and custodial schemes, and they'll have agent and landlord managed. We used to call them managed and unmanaged, but in reality, we realized they're not really unmanaged. They're just not managed by the agent, so we just changed the name slightly. And basically all the deposit schemes, there are 12 agreements in there, 4 for each deposit scheme that follow that. Now at the top of the list, jumping the other end, we have a contractual agent managed, and the second one down is a contractual landlord managed. This is for creating a tenancy that is outside the Housing Act 1988. So you will find in there, pull one of those up for you, I'll just make it a bit bigger. Then you'll be able to see it a bit better. So this is for a tenancy that's outside the Housing Act 88, company let being the simplest example of that. If I just scroll down, I want to highlight one particular point, and that is you'll see in 1.4, the bit I've just highlighted there. It says this agreement is intended to create a contractual tenancy outside the Housing Act 1988 because. A couple of things around that and the because. The first thing to say is that the because is important. If this went to court in 2 or 3 years' time, you would need to know, well, hang on a minute, why did we set that up as contractual? Why didn't we just use an AST? And the purpose of that statement in 1.4 is that you fill that in at the point you are setting up the tenancy. So you might say this is a contractual tenancy because it's not the tenant's only or principal home. You might fill it in to say because the rent's over £100,000 a year. You might fill it in to say because the tenant is a company. But it's a very good thing, a very good practice to make sure you put that in there so that when it goes to court and the judge goes, well, I think this should be an AST. Mr. Smith's living there, why shouldn't he have an AST? The person who's going to court won't necessarily have even set the tenancy up if it was several years beforehand. And so having it embedded in the document for the reason is very, very powerful. I also want to flag up these what we call tildes. They're little squiggly lines. You'll find them just next to the carriage return key on your keyboard. And whilst we've got one up here, let me just explain how they work. So if you hit Control F, which is the find facility within Word, the little navigation box pops up you see on the left. And if I type in a tilde at that point, you'll see it highlights in yellow all the tildes in the document. And I can literally jump through from one tilde to the next. Now, the idea of those tildes is anywhere in the documents that you might want to make an edit, there is a tilde. So if we look at the paragraph 1.5 on the screen there, it says the property situated at and being tilde. You're clearly going to put in an address of a property instead. So you delete the tilde, put in 23 the High Street. Obviously, if your software has merged it in for you, that one won't be necessary. If we come down to 1.5.2, you'll see that it says the property is tilde, not let as a house in multiple occupation. Now, it's quite possible you're letting it to 3 or more sharers as a student let house, and it will be. So you would take out the word tilde and you would take out the word not, so that it said the property is let as a house in multiple occupation. So what those tildes are doing is to avoid you having to read the agreement and to think about each statement and do you need to amend it, you put the tildes in anywhere you need to amend it. And then you can just jump through tilde to tilde and you can add in. So that's what the tildes are all about, and that applies across notices and the tenancy agreement. The second thing to say is that, for example, if you see at 153, it has a tilde at the beginning of that statement, and it said the license for this property allows a maximum number of tilde individuals, etc. Now, there are 3 tildes in there. One is the individuals, one is the family, and one is the tilde at the beginning of the line. And the reason the tilde at the beginning of the line exists is that depending on what you have answered on line 2 of 152, if you've said this property requires the landlord to hold a license, then you would then delete the whole of 153. If it does require a license, then you can edit 153 to make it reflect the license conditions. And what we've done, as we've done in 153, is we've tried to make paragraphs, and you can generally tell if the paragraph is a sort of a removable paragraph, like has the property got a garden, can they have pets, can they have children, all those sort of things. You'll generally find that those paragraphs tend to be at the bottom of the numbered lists. The reason for trying to do that is to minimize any renumbering that is necessary. So you can see you could delete 153 and it would have no effect on the numbering. Word does have an auto numbering system, and I did try and use that many years ago when we started. I have to say I found it a complete nightmare because it takes over the formatting of the document, and I just decided it was more trouble than it was worth, and decided to go back to manual numbering. But that's what the tilde is doing at the beginning of that paragraph. So that is the contractual tenancy. A large percentage of, obviously, of all the documents are going to be the same, because, you know, the tenant having to cut the grass doesn't matter which deposit scheme, it doesn't matter which company or let or whatever, you know, those sort of provisions are the same. Within
David, just before you go too far, leaping ahead, I've got Brian with his hand up. He's had his hand up for a while, so I don't know whether you want to try and unmute him and have a listen.
Brian, let me zoom up the list to Brian. There we go, Brian. Let me see if I can unmute Brian. Brian, I've unmuted you. We should all be able to hear you. Have a question. I notice Brian is on a computer, so it may be that the microphone is muted on the computer system. You need to go into the control panel and sound. I will remute you just so we don't get involved in that. I'll put your hand down, and then if you need to put it up again, Brian, you can do so when you've sorted out the audio. This is what I mentioned to you before. It is worth saying with webinars that there is an audio test when you log into the webinar, and it's worth going to the audio test and making sure the system is picking up both microphone and speakers. So we'll keep a little eye out for Brian's hand coming up. I just want to highlight this document here, Tenancy Agreement Notes. It goes through the agreement paragraph by paragraph, explains what paragraphs do, says you could do this in this circumstance, or you could change it for something else. So it kind of like gives you options. So, you know, quite a handy document to help you understand, certainly as you're starting and getting used to the document. We, for historic reasons, have always considered this one here, the DPS custodial agent managed, as the sort of master. So when I'm editing the document, this is the one I update, and then I copy the updates across all the other versions. And I just want to flag up one or two things, which I said I would do when we were here. The first one is if we come down to 1.6 at the top of the screen there, I can make it a little bit bigger. You'll notice that in 1.6, it actually says that the term shall be from and including tilde, to and including tilde, and then the tenancy continues as a monthly contractual periodic until ended following either party giving notice. It then goes on to say, please see clause 2.5 as it contains important information about what you must do to end the tenancy. Now, this is one of the areas that makes our tenancy agreement very different to what a lot of the industry is using, because we are not using a tenancy that simply allows you to be there for 6 months or 12 months. You are granting them what we refer to as the fixed element, i.e. the from and including to and including element, and then you're also giving them the right to remain there on a monthly periodic. And this is what avoids them going statutory periodic. The trouble with that form of tenancy is that it actually creates an agreement whereby essentially if the to and including and from including dates are 6 months apart, you must allow them to be there for at least 7 because you've promised that they can remain there monthly contractual periodic, and therefore it's important that you allow them to stay for that 7th month. But we felt that would mislead many landlords and tenants who were unaware they were signing up to a 7-month agreement when the 2 dates were 6 months apart. And so you'll see that in that clause, there is a reference to clause 2.5. And if I scroll down to 2.5, you will see that 2.5 is in simple terms a break clause. It's a very simplistic break clause. And all this wording of break clause is doing is simply breaking off the monthly periodic. So if the landlord doesn't want the tenant to stay beyond the 6 months, he can operate the break clause to end it at the end of the first 6 months. If the tenant doesn't want to remain for the 7th month, equally they can serve notice and end it before the 7th month. However, this is not a clause that ends the tenancy any earlier. This does not give you the sort of ending it at 6 months out of 12, hence why we give you the wording in that other document so that you can sort of copy and paste the wording in to replace 2.5 here with one that will end it earlier than the fixed term, what you might call a more conventional break clause. But I just wanted to highlight that point because it's important that you understand that to ensure that you use it and use it correctly. We don't want people being misled and not understanding. Now, the last document, last folder we have here is the standalone prescribed information, which is just simply the 3 deposit schemes, custodial and insured, and whatever the up-to-date prescribed information is. Most of the things that have changed in that over time is where schemes have changed contact details or something of that nature. But I said there was standalone prescribed information, and that's what this is. It's just simply to enable you to complete the prescribed information and give it to a tenant in a circumstance where you are not setting up a new tenancy. In the master folder here, you'll also see a couple of other documents. We actually track all the changes we do. So, for example, you can see changes for revision 311A. That is a list of all the changes that were made in 311A so that you can know what was changed when. That's the purpose of that document. So I'm just going to switch over and look at the how the management forms work. That covers the tenant application forms, contractor paperwork, general data protection. I've got a lot of documents there to help you with that. Legionella and your responsibilities around that. Things to do with the property condition and the terms of business, your agency agreement with the landlord. So again, exactly as we saw on the tenancy agreements, it's split between England and Wales because there are some differences, particularly, for example, now that the tenant fee ban has come in. It's less different, perhaps, than the tenancies folder, but there are some differences nonetheless. So list of folders in there, much the same as I've just shown you. So looking at the application form, you'll see that we have essentially the top 3 documents are 3 application forms: a company application form, a guarantor application form, and a tenant application form. One of the things I've learned over the years is that we've increasingly handed over the referencing and setting up tenancies to external companies who tend to ask the questions they need to in terms of the financial probity for referencing of the tenant, but they don't ask a lot of other questions that we as agents need to know. Very simple example is they don't generally ask you who is going to be paying the deposit, whereas we need to know that because if the deposit's being paid by anybody other than the tenant, then they will be a relevant person. We need to collect their information, put it in the prescribed information, give them the copy, etc., as we mentioned earlier. What we also have is the bottom 3 documents are just information. They're user guides for those 3. And what we recommend with these application forms is that you compare it. If you use an online company, look at what information the online company are collecting, and if there are questions that are not being asked, then you can strip out some of the questions from our system. It's done in a table in Word, and then you can just get the tenant to fill in those remaining boxes that you have not managed to collect via the referencing company. The second one is contractor documents. We could run whole webinars just on contractors and contractor documentation. It's an area where, from experience, we know there are some serious problems. We know of agencies who have had, six-figure penalties as a result of not getting this right. So it's important that we get it right. But it's also fair to say that for most agents, what tends to happen is that somebody comes to the door and offers you £5 off your gas safety checks, and an agent goes off and uses them. And that is where the problems occur. So this is designed to give you more of a system. Some of it, for example, the works orders, may be within your software. So you can either use it or not, depending on what the one in your software allows you to do. But even down to an application form. Most people do not get a contractor to fill out an application form so that you've got all the right information about them, where they live, bank details, qualifications, insurances, all this sort of stuff. So this is what this is designed to do, to formalize the collection of that information to ensure that you're doing the right thing. The next folder is the GDPR folder. This has two subfolders. The reason we split it was simply because there are, I think it's about 15 or 16 different privacy notices. So you can see that little list there. That's 16 notices and a README for the privacy notices. And that is, in order to make your privacy notice real, it's no good saying that you can't have a generic privacy notice that says to your landlords, we will be using your bank details in order to pursue you for unpaid rent, because clearly you're not. And so it would be inappropriate. So what we recognized when teaching GDPR back in the beginning of 2018 was that essentially you would need multiple different privacy notices, because if you take the situation where you get an applicant or an inquiry even, they just interested, have you got any 3-bedroom houses in this area? At that point, we don't hold a lot of information, and we're going to do certain things with it. As they progress through our sausage machine and they make an application, do a viewing, become our tenant, we're going to gather more data, but we're also going to be using their data for different things. And so we provide various versions. So you'll see that you've got a tenant inquirer, tenant applicant, tenant privacy notice, so that you give them updated privacy notices as they go through the system. So that's almost, I'll use the description, the output of the GDPR. The ones in here are other things. I would use the description that the third document down, data analysis blank template, is at the heart of doing this right, and this forms part of your privacy notice, the two link. You are required to have a data audit showing this is the information that we hold. Many years ago, when you registered for data protection, there was an enormously long form. I remember filling it out in paper form before it was done online. And there was pages and pages, and you basically had to tell the information commissioner all the information you held and what you did with it. Now you're no longer required to tell them all that information, but you are required to have a record of it so that they can come to your office and say, we want to see your data audit. And you would have to go, well, here's the data I hold. This is what I collect it from. This is who I give it to. This is when I'll delete it. And that's what is in that audit. There's a blank one there for you to sort of fill out. But there's also an example, purely hypothetical, just giving you some ideas to try and help you understand how to use the form. A lot of GDPR, back at the beginning of 2018, there was a lot of focus on consent. I would say that the vast majority of the processing of data we use does not use consent as the lawful basis of processing. We would either have requirements that are in the law or in the contract. Those will be our two most common reasons for processing data. So I can process the tenant's data in order to arrange a gas safety check because the law requires me to get the gas safety check done, and that therefore gives me the legal right to process the data. I might have a contractual responsibility or ability to collect the rent. So if the tenant doesn't pay the rent, I'm allowed to process their data, i.e. look up their phone number and ring them, based on contractual fulfillment, which is another one of the lawful bases of processing. So there is a consent. The one that consent is most likely to apply to is actually going to be any form of marketing. So if landlords or tenants contact you and you want to stay in touch and send tenants lists of available properties once a week or whatever, that's probably an area where you do need their consent. And therefore, that's where we give you that consent document. We've got one here for staff members, because don't forget GDPR, not only do we have to think of landlords and tenants, we will hold staff personal data, names, addresses, phone numbers, etc., national insurance numbers. So we need a privacy notice for that too. Where your basis of processing is a legitimate interest, that is one of the 6 lawful bases of processing under GDPR. The law requires that you do a legitimate interest impact assessment. So when you fill out the data audit, anything you say, I'm going to do this as a legitimate interest, you need to make sure that you've dealt with that on your legitimate interest impact assessment. We've provided a fact sheet to help you explain to landlords about GDPR. It's a common question we get. Our line on this is very clear that any data you are processing as the landlord's agent is owned by the landlord. In other words, he is the ultimate data controller because at the end of the day, he might say to you, I want you to send the tenant's detail and file over to the solicitors because I want him to serve Section 8 and seek possession on the basis of rent arrears. And the definition of a data controller is the person who makes the decisions. And so the landlord is undoubtedly, in my view, a data controller. They should register with the Information Commissioner. And this is just to help them understand that. Checklist of things to get ready. Hopefully most of you should be past that already. You are required to have an information security policy. You may have read recently of an agency who was changing software, and they uploaded all their contact details of all their clients onto what amounted to a cloud-based system so that their software provider could collect it from the cloud-based system, and then it sat there for 18 months, not password protected or anything else, and anybody could have looked up, everybody's names, addresses, bank details, and everything else, and it resulted in a fine in the tens of thousands of pounds from memory. And the information security policy is the sort of first description or the first step in defending yourself to saying, no, we do have a policy. So several documents there, that's all around GDPR. You can read the rest, obviously, at your heart's content. Legionella management, you've got a letter to send to landlords so that landlords understand it. We actually produce our own Legionella risk assessment form that if you choose to, you can do your own Legionella risk assessments. They don't have to be highly technical and complex, so that's the paperwork to do it. Obviously, the people doing it have to have a degree of knowledge. Part of Legionella is what the tenant does, so we have a tenant's guide to Legionella as well, so that they know that if they've been out of the property for several weeks and it might have bred Legionella, they should drain it through, etc., those sort of practical things. And then there's a document about using the Legionella risk assessment. I think on the website shop, we have a Legionella risk assessment webinar. Property condition, this is something we've actually brought in specifically really around the fitness for human habitation. It is now a requirement that all properties are let and kept fit for human habitation. And so we have a checklist here for assessing that, so that you can, if anybody queries it, you can show actually we did check it before the tenant moved in, and we've linked that to the periodic visit checklist. The Rogerson versus Bolsover Council was quite an interesting case we were talking about on the legal update at the beginning of this year, where the tenant fell through a manhole in the garden, and essentially the landlord was found culpable because they could not evidence what they had checked when they'd done a periodic visit. And so obviously the evidence is you need to be able to show what you were checking, and that's just a simple form of assessment. And the final folder here we have are the terms of business, starting at the top of the list with the agency agreement. The way we have structured the agency agreement is it builds, so you essentially offer a tenant find type service at the bottom end, and if you want to do that, the next level is the letting and rent collection, which is the tenant find plus these additional things. And if you want full management, that's the letting and rent collection plus these additional things, so it all builds up. It also gives you a sort of an upselling opportunity, because by having it all in one, you can show the landlord how he gets additional things if he upgrades to the better one. We have put the scale of charges into the agency agreement because it's a property ombudsman requirement that it is part of the agreement, but we also provide a standalone scale of charges, and that of course is because it's a legal requirement to have a scale of charges displayed in your office and on your website. So that just gives you a way of ticking that quite easily. Property details is just about collecting the information you need in order to manage the property. Complaints procedure, self-explanatory. Again, TPO require you to have a complaints procedure that the tenant must follow before they complain to the TPO. And so we're just giving you a model complaints procedure. You will need to put in people's names, who should they speak to if they're not happy, and who should they escalate their complaint to if they're still not happy. We put the fee increase letter in at the beginning of the year, knowing that the tenant fee ban was coming in. We felt many agents were going to look to write to landlords and increase the fees. So that was just a model letter we created for that purpose. And then a number of checklists for moving in, moving out, et cetera, along with the notes on this part of the terms of business. I've always split what I call the legal, i.e. the agency agreement, from what I've referred to as the promotional side. So in the promotional side, we give the landlord lots of other information. We never used to give that promotional side until later in the process. In other words, once they'd signed up, and that's a good way of stopping your competitors knowing what you're telling landlords, because until they sign up, they don't see the rest of the information. You split it into a two-step process. So lots of documents there. I'm not quite sure how many there are in total. The Welsh ones are pretty much going to be the same. In some cases, they're identical. What we've done in the Welsh version, if I go across, in fact, let me jump across to the tenancy agreement side, and then jump across to the Welsh ones. What you see in the Welsh one, if I go to notices, for example, you'll see Schedule 2 grounds there says 311C Wales, and that, because it's got Wales in the name, it tells you that is a form specific to Wales, and it's different from the one in the English version. There is a version in the English, but it's totally different. Where the name is the same, and it doesn't say Wales, then it's probably the same document in both folders. You can use either. But we did identify the ones that are Welsh specific, if I use that description. You'll see that the Section 8 notice is Welsh specific, as I warned you. And of course, Wales does not have Form 6A because they're going down the route of occupation contracts. They won't be using Section 21, so they chose not to follow the English route. I hope you feel you've learned. As I say, we've tried to record it, so therefore recording working. We will make that available so that if people want to listen, they can have a revision. It also means that other members of staff can listen who maybe weren't available at this particular time of day, or even members of staff who maybe don't work for you yet. It gives you a way of giving them an overview of the documents that we've provided. Within the, if I use the word within the system, the way we work, what we also have is a bespoke email address for documents. So you would normally email PFG helpline at TFP Online if you have a particular query. But if your query is about a document, it's not a question of what date do I put on a Section 21 notice. That will still go to PFG helpline. But if you, the sort of thing we often get is people, a tenant or a tenant's advisor has queried a comment in a tenancy agreement, then if you just email the documents at TFP Online address, that's because they are dealt with in the office here. They're not dealt with by the external helpline advisors. That is our time up. Time rushes by when you're having as much fun as we are. So I see Claire has said there, I believe there's also a Welsh specific Section 13 notice. Indeed, there is, and you'll see there that Section 13 notice Wales, so you see there is a Welsh specific one, and that's included in the pack. So just to answer that little query I happened to notice. On that note, I'll thank you very much all for attending and wish you all the best. Thank you.